I got a notice on this thing live stream.
There we go. Nothing will stop us go. Welcome back. We had some technical difficulties. Another Hump Day Real Estate with Kendall in the DMV. I hope you stayed around if you're out there trying to take a look. But we have a special guest. Who do we have with us today?
Oh, you want me to introduce myself? Sure.
I want you to introduce yourself.
Hi, my name is Sherry Fleming. I am a Maryland licensed attorney, an accredited estate planner. So since I'm introducing myself, I think it's important just to note that I'm here to provide information. I'm not providing specific legal advice to you or your audience. I'm just here to provide information about estate planning and just have a conversation with you and answer some questions. Maybe I can get some answer to some questions that may be out there, but also I just really want to encourage everyone who is listening. Take everything I say and go seek a legal professional for assistance regarding your specific situation. I find that people, have followed the TikTok attorneys and get information on podcasts and other social media outlets, and they run with it, not realizing that they're running in the wrong direction because the information doesn't always fully apply to them or apply to them in a way that they think it does. So you should definitely seek professional, at least a consultation about your specific situation if you hear something here today that is of interest.
Appreciate that. One thing that I wanted to bring you on the show, I wanted to help our folks understand, what is estate planning or what is an estate planner?
Yeah, so estate planning in a nutshell is planning for your life. A lot of people think that estate planning, you hear different titles. You hear wills and trusts, you hear probate, you hear different titles, but estate planning is really planning for your life, your current life. Right now, everything you own belongs in your estate, from the shirt on your back to the shoes on your feet, the cash in your bank accounts, the Bitcoins that you have. All of those things are within your ownership or within your estate. And so when we talk about estate planning, when I talk about estate planning, because also the language may be the same, but some people use it differently. So when I am talking about comprehensive estate planning, I am talking about goal setting and goal reaching. Those goals can be financial, personal, goals that you want to reach. They could include retirement planning, long-term care planning, planning for aging, disability, and then also death, planning for a time in which you're not here, because all of your possessions are going to remain. There are desires that you have for yourself and maybe for your family members to reach those desires. They may go beyond your lifetime. So estate planning is really being real clear about your vision for your life, your vision for yourself. What does it take to accomplish that? And if it's something that can't be accomplished in your lifetime, what does it look like when you're no longer here, and who is in charge of that? And so again, it could include retirement planning, retirement preparation, long-term care planning. Wills and trusts are tools. All of these things are tools. Financial planning is the bedrock, the foundation. In estate planning, it's not just about finance, because it is also about healthcare, because you are a person, but financial planning is key to that. And so all of that, to me, it consists of comprehensive estate planning. I will tell you right now, you will speak to different professionals, and depending on industry, depending on if they're in tax, if they're in finance, if they're in law, if they're in healthcare, they may have a different answer for you.
Now, most of the time I'm hearing about estate planning, think of maybe wealthier folks that are wealthy, and you don't really hear of anybody middle class, lower class really talk too much about estate planning. Is that what you've seen throughout your career, or uh, I just haven't been in the right lanes? Or
I think we're in a place and space and time where the conversation about estate planning is changing, because the individuals prompting the conversation, what they look like, are changing. So, for example, I am having this conversation, and estate planning for me has and always has looked very different from others. And so, what I like everybody to think about when they're watching this and they go, estate planning is for wealthy people. Well, well, first of all, what is wealth? First of all, let's define what wealth is, right? And so, in a financial sense, wealth is assets minus liabilities. What is the value of your assets minus the debt, the liability associated with those assets? You have your net worth, right? In a financial sense. But estate planning isn't just about finances. And that is what I need everybody to understand. Estate planning, finance is a portion of estate planning. Estate planning also is about who is going to care for your minor children in the event that you are disabled or you decease before they become of a legal age, which in most cases, depending on the situation, can be anywhere from 18 to 21, depending on jurisdiction. And so estate planning also is, well, what happens if I'm disabled? So in this world of technology and modern medicine, we have more people who will live with lacking capacity to make decisions than actually dying. And so if you are in that situation, you're not dead, so your will doesn't kick into place. Who is making decisions for you when you cannot? So when you begin to think about it like that, you begin to see a whole lot of people who should be estate planning. And so some people hear me say this and it triggers things for them because maybe they had a bout of sickness and they realized that they needed support and they couldn't make decisions and they needed someone to make decisions. Most people are triggered when they have to bury a family member, a spouse, a parent, and they realize that their regular everyday person that has now transitioned, it required a lot to actually transfer their assets and to actually provide them with care. And they recognize that they need to do some pre-planning to make the burden not as heavy on those who come after them or who their caregivers. And so for everyone, I will say, look around you. Who do you know? Everyone has a story. Everyone has a story of someone's uncle or someone's parent who passed away, didn't have a will, the family are fighting over the assets, or did have a will and they didn't like the way that the things were distributed. Like everyone has a story. And when you look at those stories, ask yourself, who are these people? 9 times out of 10, they're everyday people. The high net worth is not even 10% of our population. So what is happening with the other 90? And it's the other 90% that I represent. It's the other 90% that I advise. And it's the other 90% that have some of the most complicated legal matters that they don't even recognize to be complicated legal matters. And so that's why I come and I do these podcasts, because quite frankly, I'm tired. I'm exhausted. So I need people to get their stuff in order.
So listening to you say that, okay, so I don't know if I'm gonna be wrong, and you know the
Go ahead.
legal
I'll
parts
clean
of it,
you up.
but if for a long time, folks been getting that baby's Christian, so there's godparents. Where does that where does that play? Now we're talking about some legal estate planning. Where does that godparent play in that role? Because there's no uh, you
It,
follow what I'm saying, right?
it doesn't, it
Where I'm
doesn't, it
going.
doesn't, it doesn't, it doesn't, it doesn't, it doesn't mean anything. So first, let me say this, let me get this out. So I'm wearing a shirt, it's Our Legacy Matters. Our Legacy Matters is a campaign that I started around 2019-ish. I started my practice in 2015, and I started really pushing estate planning in 2018. So in 2018 and pushing this practice, I recognized that most everyday working people have no clue of what estate planning really is. And so just to give you context, I think the percentage is like 47% of all Americans don't have wills or do have wills. 47% do have wills. And 27% of those individuals, or not that number, but 27% of African American people have wills, right? And so I recognize I needed to make a connection between the professional world that I worked in and the family that I go home to, the cookouts, the baby showers, the baby blessing, the baby, what do we have now? Gender reveals, we go to all of these family things, and there is a complete and utter void between these two communities. And so Our Legacy Matters was a way for me to kind of close the gap, to give vetted professional information, not specific legal advice, but just accurate information, baseline accuracy. Because I would have, the questions coming, and I can't answer every question, but so it's a group that I created. Moneyandmemories.com is a website. You can go, it's a private group. I'm not disseminating information to everyone. I have some frequently asked questions, and you can submit questions there for anyone who wants to be a part of it. But it's a great network of people who just want vetted information. No advice is being shared, no money has to be paid. So that's moneyandmemories.com. So the reason why I mention that is because I get these questions. That question prompted me to say that. What is the role of a godparent? Nothing. The role of a godparent is what you want it to be. So I have 3 daughters, 2 of which are teenagers. She turned 6 next month. And my husband and I, with our first kid, we were just like, okay, like godparents is a thing, right? And he had amazing godparents, and I had like my godparents, we're not that close. My godparents were older. And so it was just different dynamics. I'm from New York, he's from Philly, different dynamics. So when we had our first kid, we were like, all right, so like, do we have to do this? Like, is this a thing? Like, and culturally it is. Culturally for us, having godparents is a thing, right? So we're like, all right, so what is the criteria? And then we're like, but wait a minute. Are these people, what is the expectation that we have of godparents? And so we literally put all of our children have sets of godparents, and we have them in tiers. Okay. We have them in tiers. And so there is no legal obligation of a godparent. Like there's not, the only legal obligation that exists is that of a biological parent. Okay. And then there are people who become legal guardians. And then we may have custody arrangements where grandparents or someone become a custodian. So those are like legal terms and legal arrangements. Everything else is fake. Okay. It's what I refer to as fictive kin. Particularly in our community, we have a lot of cousins, a lot of aunties, and ain't nobody really a cousin or auntie, right? And so there is no role of a godparent. Now, what I have done personally, and what I've seen other people do, and it depends, in our top tier of godparent, those are the people that we have named to be legal guardians of our children in our will in the event that both of us transition. Okay, so that's the top tier. You are in charge of the person of the child, and you are in charge of the property, any money that that child is entitled to. You are the legal guardian in charge. You are the top tier godparent, right? Then we have our other godparents, which we call, the second tier. They're village members. They're regular old village members because it takes a village to raise a child, right? And so these village members are the one that I call, and I'm like, listen, you need to get her. You need to get her because I'm about to rip her head off. You need to call her. You need to get her. I need someone else to step in. Those are our tier 2. And our tier 3 are just to show up on a birthday, give a check and give some money because, hey, we're your godparent. And so we do have different versions. And with all of these people, we have had conversations, like interviews. What do you expect? But a lot of times we go into creating godparents. There is no legal obligation for that person to do anything. Also, if that is the expectation, you better make sure that they're suitable to actually be appointed to serve in that role, because a court isn't going to appoint just any old body in the event of your incapacitation. And also be very clear when it comes to children, there takes two adults to make a child, right? And so those 2 adults have a legal guardianship. An absent parent doesn't change his or her legal rights. Only a court order can. And so there's a lot of layers and complications to that people just typically don't understand.
Wow, that's lovely how you guys broke that down. That's amazing. And have you shared that before?
Yeah, I do it all the time. I actually, when I
Okay.
do, yeah, so I like to speak to groups outside of webinars like this, video podcasts like this. I like to speak to groups. So I speak to caregiver groups. I speak to groups of mothers, and I let them submit their questions in advance. And so, I do like three myths. I usually come in with three myths, and one of the myths is this. Should something, if I am a mother who is a single parent, and I'm a primary caregiver, um, whoever I designate, or maybe a godparent will take care, it will be legally responsible for taking care of my child. That's a myth. The reality is the only other person with a legal responsibility to that child is the other parent. And if that other parent rights weren't terminated or voided in some way by a court system, because they are constitutional, well, not constitutional rights, they have a high hierarchy, in how valuable these rights are. And so if that parent's rights were not terminated, if something happens to you, primary caregiver, custodian, then that other parent has a lot of rights, a ton of rights. And it really depends on the jurisdiction that you're in as to whether or not their rights will trump or supersede the rights of a grandparent or the rights of a sister who would serve as an aunt. And so you got to know the law of the land of where you live to know how this would work. So that is a common question. So yes, I answered a lot, as you can see.
Well, what I'm going to say to all of that is, godparents, be very careful what you also sell to the godchildren, because godmommy, you know who you are. I'm still waiting for my skateboard. That's what I'm doing. That's but I had to get that one out. I had to get that one out. Yeah, her and I crack up about that every time I talk to her. I'm looking for my
Mhm.
skateboard. But so one of the other major things that we're talking about is one of those pillars of estate planning, and that's living trust. And
Mhm.
I have 10 questions for you in regards to that. What is a living trust?
Okay. So I want to be very careful about terminology here because depending on who you talk to, there are a lot of different terms that seem similar that aren't the same. Okay. So when you're saying living trust, I'm going to tell you what I interpret that to be. I interpret that to be a trust that someone can have for themselves as a beneficiary while they are living, right?
Mhm.
That's what you mean when you say that?
Yes. Yep.
Okay.
Yep.
And the reason why I say that is because, again, there's a lot of terminology that gets mixed. And in some places, when you say like living will, that's not a last will and testament. That can refer to an advanced medical directive. So when you're talking about trust, so I'm going to use bucket categories. I'm not going to use the term living trust. So when you talk about trust, they typically come in three different major buckets. You have a testamentary trust that's created by your will. So your will directs the executor of your will to create a trust for the benefit of a group of people at your death. That's a testamentary trust. Then you have a revocable trust, which is where you can place your property that you own in trust for the benefit of yourself and others. And you would serve as trustee. And upon your death, you would name a successor trustee, which could be an individual, an institution. Okay. Then you have an irrevocable trust. Let me take a step back. The idea behind a revocable trust is just that you can revoke it. So you can put assets in the trust as a trustee and take them out of the trust as a trustee. You have power over all of the trust assets. So the third bucket is an irrevocable trust, and it is just that you can't revoke it. So you would put assets into a trust. One critical aspect of it is that you have to name a third party trustee. You cannot be a trustee. You have to name someone else, and and it could be an individual or an institution. And you, in theory, cannot take the assets out of the trust. Now, there's this process of decanting, which is decanting. Think about these terms come from almost like wine, decanting wine. And so it's not that you're breaking down the trust into different components. So you're decanting it, and that is equivalent to making changes to the trust. But that is a legal process that requires court authorization. The trustee has to go to the court to be able to decant an irrevocable trust. So the idea is that you put assets into the trust not to get them back. And so I jumped the gun a little bit because I don't want to assume that everyone even knows how a trust works. So let me take a step back. And at a very basic level, a trust is giving your items to someone else for the benefit of another person, in theory. Okay. So I, Sherry, give to Marcellus in trust for Christina. Okay. I am the settler. I am the creator of the trust. Marcellus, you are the trustee. You are in control of the trust, but it's not for your personal benefit. You are serving as a fiduciary for the benefit of Christina. Christina is the ultimate beneficiary, and there is some particular reason why she's unable to control the items or the property for herself. It could be because she's a minor. It could be because she's an individual with a disability. It could be because she's an older adult. It could be there's other issues of capacity. It could be that we don't want to give her assets in her name because we want her to have access to governmental entitlements. So there are different reasons why we wouldn't want to give the property to Christina outright. I wouldn't want to give the property to Christina outright. So therefore, I give the property to you, Marcellus, to hold and to serve, having a duty, the same duty that we learn in real estate. And what is it, cold IC? So the duty of confidentiality. I forget what the O is. I forget what the O, the L is loyalty. Honesty is in there somewhere. The communication is in there. So all of those fiduciary duties that we have, that's what a trustee has, those duties. And it's a heightened level of a watch that's given to the trustee to make sure that they're not misappropriating funds. And really, the trustee can only act within the parameters spelled out in the trust. So when you're creating your trust is your document, it's a piece of paper, right? Mm-hmm. And so when you're creating this document, you're giving instructions and you're giving parameters to the trustee as to what the trustee can do, can't do, when, where, and how. Okay. Right. And they control the assets with those instructions. You would control those assets with those instructions for the benefit of Christina. That at a very fundamental level is how a trust works. In the state of Maryland, I can't speak for all jurisdictions because I don't practice everywhere, but in the state of Maryland, I can create a trust as simple as endorsing a check, to Marcellus in trust for the benefit of Christina. That I have created, I have given that money, that property, that note to you for Christina's benefit, and I have created a trust. So it can be that simple. It's not a complex thing to think about. That is fundamentally how it works. And now, so I mentioned these three categories, right? And mm-hmm. So if you're doing a testamentary trust, you have a will where you're saying, this is how I want things to be given out directly to people at my death. These are the things that I want paid and dispersed directly at my death. However, whatever's left over, depending on what it is, I don't want it to go directly to this beneficiary. I want a trust to be created with these assets for the benefit of this beneficiary. That's a testamentary trust. Again, a revocable trust is you creating a document saying, I, Sherry, am putting these items in trust for the benefit of myself and others. So I am both trustee and beneficiary of a revocable trust. And then typically with a revocable trust, you're naming a secondary trustee in the event of your incapacitation or your death. And that secondary trustee steps in. And at that time, the trust goes from being revocable to irrevocable. And the third type is that an irrevocable trust where you're putting assets in trust, putting a third person or organization in charge for the benefit, again, of yourself and or others. And so that's people go, oh my gosh, that's it? That's so simple. Yes, it really is that simple. We get paid a lot more money because we make it seem complicated, right? But in theory, it really, really is that simple. Now, where it gets complicated is in the tech, the strategy that can be used with trust, and this clear fact. Your trust is your document. It can be 2 pages, it can be 20 pages. That is your trust. It is private. It's a document you keep, the trustee keeps, the settler keeps, maybe the beneficiary see it, maybe not. You may not want the beneficiary to see it, but it's private. And the way that a trust actually works is that you have to retitle the things that you own to the trust. So if I create the Sherry Fleming Family Trust with Marcellus as trustee for the benefit of Christina, and I am putting my house in trust, I have to have a deed drafted to transfer my house from the ownership of Sherry Fleming to the ownership of the Sherry Fleming Family Trust, which now has its own tax ID number. It's its own entity that exists. The main thing that I see go wrong in a lot of trusts with people who don't have accurate information, with people who go to attorneys and the attorney will do exactly what you paid them to do, but you don't read to follow the instruction that they gave you. Is that they will give you a trust and they'll give you this big binder. You feel real confident because you have a big binder with this great stuff in it. You pat yourself on the back because I got a trust. Everybody's been listening to Jay-Z 444 and generational wealth is happening. Kudos to me. But you never actually read all of the things in a binder. And so what happens is that you get your trust set up. And depending on what conversations you had about the work that you agreed for the attorney to do, a lot of people, and I'm realizing my practice is not like this, but I'm realizing a lot of people get the trust document, but they never have the attorney do the service of retitling the asset. And I'm also realizing that not all attorneys retitle assets, which is perplexing to me. And I know the reason why, but it's perplexing to me. And so if you are going to get a trust and you get a binder, but you don't have retitled deeds, you don't have a retitled certificate of title for your car, there are no names changed from your name to the trust name on bank accounts. If none of that happens, all you have is a nice binder of paper.
Question to that, because that you made that point. Now, are they not doing it because their mortgages tied to some of the assets, or there's stuff tied to the assets that maybe something may come due because if they make those changes?
So but that's a part of advising. And again, I'm not trying to judge or knock anybody else's practice, right? In my opinion, that's a part of advising. 90% of my clients come to me saying, I want to trust. And I go, okay, well, let's talk about that. Let's talk about why. Let's talk about your why. Let's talk about the goals you're trying to achieve. And let's talk about your assets and let's talk about your liabilities. Let's look at the big picture here. Let's look at your goals and let's look at the way in which you want to achieve your goals. Let me also tell you about these other 2 or 3 ways that you can achieve your goals and let's figure out which one is best for you, right? So part of advising is being able to say, hey, If you want to retitle this house into a trust, you have a mortgage on it, you need to contact your mortgagee, contact your lender. Will they authorize this? Because most mortgages that are recorded, these are public records in most states, they have what's called a due upon sale clause. And it's in there, it's clear as day. And what it says is, if you make any alterations, changes, transfers, anything related to this deed, that the mortgage company has the right to cause the full balance of the mortgage to be due for immediate payment, right? Go and read your mortgage. Again, comes back to reading. Go and read your mortgage. It's in there. I read it. It's in there. It's usually on the second page, right in the middle. And it's standard in most mortgage contracts. And so I explain that to my client and I say, well, if you have a mortgage and you transfer, this is a possibility. And I say all this to my clients also. I hear from my colleagues, I'm a part of several professional associations, more than I probably should be, okay? But as a solo practitioner, I like to network, but I'm a part of several professional organizations. And I hear attorneys, what they tell their clients, because they share with me, and they say, yes, this is a possibility. It's in your mortgage contract, but in all my years of practice, I have never seen this happen. So I don't know how much you should worry about it. What they don't also say is, it's your risk to take, not mine. It's your risk, not mine. So I tell my clients that. I tell them, what other attorneys say. I also tell them that it's your risk and not mine. The other thing that I also say is, I have seen mortgage companies say, you made this transfer without our authorization and we want the full balance. I have seen it. So I can't say I've never seen it happen. I have seen mortgage companies request, well, let me not say it plural. I've seen it happen once. That's all I needed to see. And it wasn't my client. It was another client that was coming to me for help. And I was just like, oh, I can't help you. I wish they would have told you this. But yes, this is a possibility. So yes, you're right. There are ways around that. That I talk with my clients. One way is just contact your mortgage company, see what they will agree to. I have a lot of, deed changes that happen because of marriage. Which, depending on the state, the spouse gets a legal entitlement to the property anyway if it's used for marital purposes. So mortgage companies know that, so they'll agree to that. But call the mortgage company, see what they say. Will they agree to it being in a revocable trust? Some do, because again, as a revocable trust, you are the same. You still have control over the asset the way that you would have control over the asset during regular ownership when you put it in a trust. So, see what they say, look for their agreement. And if it's a risk that you're not willing to take, then maybe putting that asset in a trust isn't for you. And we need to talk about alternative vehicles to meet the goals. So that's why when I do estate planning, I start off with goals and desires. That's the starting point, because I need to know the driving force for decision making. Because there's one way to skin a cat. That's a poor example. I've been trying to get a better statement to say, because I have some pet friends that's like, you need to stop saying that. I don't care about pets. So I need to come up with something different. There's more than one way to do a thing.
They don't all have cows. There's a way to skin a cow.
Yes.
Well, one little, I'll throw a little nail in there. So you watch Power Book?
No, I don't watch much TV.
Man.
I know. I'm sorry.
So I just wanted to use that one because and there, if anybody shared that with you, Tariq, the son of all the craziness that's going on next door.
I know. I watched the original show, and then I was like, "Time's out. I don't have time to watch TV." But so okay, so I know a little bit. So go ahead.
So you know about when the father died and all of that stuff, and then he had a. So what did you get as far as that the guy that actually does his trust?
Mm-hmm.
You see as far as that part? Okay.
I didn't see any of that.
Yeah, I wanted to see if we could use that as one. Which one was it, irrevocable?
So explain it to me, and I can tell you.
Well, he has, if I can remember correctly, so he has a trust where his father. There's a trustee guy that he has to go to in order to get everything done. So I think that's the person or company that that his father put in place.
Hmm.
And in order for them, that he has all this money or whatever, but in order for him to get to the money, he has to finish college.
That's a stipulation of the trust. Yes, that's a term. Hmm.
Yeah. And so they have to go through that whole thing, and that was the whole big, but that's what I just started that, and I said, wait a minute, well, some people that might watch Power, that might be interesting for them to have a
Yeah,
little
so
idea.
I can tell you right now that that more than likely is an irrevocable trust. The reason why you have to look at who is in power, who has authority, right? So it is the trustee there that is the controller of all things for the benefit of Tyreek, and because the father was the settler, the creator of the trust, that maybe the father was the trustee, and upon the death of the father, this other trustee came in a place in which it became irrevocable. Maybe it was a testamentary trust in which on the death, I doubt that it was. It sounds like it more than likely, it sounds like it probably was a revocable trust. That, and again, we're talking about a fictional show, right? But it sounds like it was a
Mhm.
revocable trust that became irrevocable. And the bottom line is Tariq, he doesn't have control
Right.
over the trust. He is bound to the terms that his father put in place when his father was living. The trustee is bound to the terms. And so it sounds like that one of those terms was in order for Tariq to either to qualify for certain access to certain assets to the trust, he has to finish college. A stipulation could be that in order for Tariq to become trustee himself, to be eligible to serve as trustee, he has to do some things, which includes um, graduating from college. So I don't know where it goes there, but for right now, based on what you said, it definitely sounds like he's a beneficiary of the trust. If he has, does he have the ability to eventually become trustee? Would depend on what the trust document says about
So,
the necessary qualifications of a
got
trustee.
gotcha.
Okay,
Okay.
because here's the thing: after every trust document, trust, with the exception of four states, Delaware, I want to say Delaware, Nebraska, Arkansas, and I don't know. I think I may be wrong on the other ones. I'm trying to think of the letters, but definitely Delaware. There are about four states. With the exception of those four states, perpetual trusts aren't legal. So the type of trust that can exist depends on what the state law allows. Okay. So like in Maryland, you can't have a trust into perpetuity. Essentially, what that means is that the trust has to end at some point. It can't be forever. It has to end. And there are four states that will allow trust into perpetuity. Some terms I've seen lately are like a dynasty trust, meaning that it lasts forever. It doesn't ever have to come to an end, so long as there are certain criteria met for these trusts to be funded and to exist. That's not the case in Maryland. And depending on the situs of the trust, the situs is the jurisdiction that has oversight, the law that has oversight of the trust, that will determine what rules apply, right? And so I don't know this trust, but let's say I know that the show takes place in New York, right? New York is not one of those states where you can have trust into perpetuity. So at some point, this trust will have to come to an end. So the trust document needs to provide some detail about when the full disbursement of income and principal in a trust has to happen, whether the parameters around it, is it when he reaches a certain age, when he meets certain criteria, what are the parameters around this trust ending? Because again, state law outside of those particular jurisdictions won't really allow for trust into perpetuity. So what happens, and what happens if he doesn't finish college? The trust should have, if written properly, it should have some direction to say that if he doesn't finish college, this is what happens to the assets. They could go to charity, they could all go to a sister, they could go to whomever. but the trust has to give information about that contingency plan. A well-written document I should say.
Gotcha. Yeah, we're talking about it, so that's the first thing that popped the
Yeah.
light bulb type. Like, what happened? What happens
No,
with
not
that?
a
I wonder if we can
problem.
tie that into that. So with all of that, so what property can go into a living trust?
Anything that can be tied. I say anything, and I say that jokingly, but anything. When I say anything, we're mainly looking at those things where we can evidence ownership, right? And so, what items do you have where you can evidence ownership? You have deeds for real estate. You have certificates of titles for cars. You have certificates of authenticity for artwork, jewelry, furs, certain leather goods. You have certificates of authenticity for NFTs, non-fungible tokens. When we start talking about, the metaverse and Bitcoin and all of these things, you have bank accounts can be authenticated, stocks and bonds can be authenticated. They all have evidence of ownership. So those things that have evidence of ownership can be retitled. See what I did there? Can be retitled to the trust from ownership from Sherry Fleming to the Sherry Fleming Family Trust, right? But there are a host of other things that you own that you have title to that there is no evidence of title of. Your clothes, your jewelry, your computer. Now these devices are getting fancy, so some leather goods and some devices, you do have certificates of ownership for them. And I only know this because my husband's a tech guy, so that's a little different. But like my little MacBook that I'm on now, like my evidence of ownership is my receipt, right? These things are called tangible personal property, right? And so the thing where there's evidence of ownership, you can retitle it to a trust. Where you own things, there's not evidence of ownership, then those are typically the things that you have to disperse via your will. You give out, you say, I want my daughter to take my shoes, and I want, my take my furniture to Goodwill unless it's the good stuff and somebody wants it. So typically anything that can be evidenced, your ownership can be evidenced to change title over from your individual ownership to an estate can go in the trust. Intellectual property, where you have patents, trademarks, copyrights, all of those things. And then the strategic question that's then asked, that we have to ask is, well, do we want those things in a trust? Or do we want them in another vehicle? There may be strategic reasons why we want to put them in separate trusts, or we want to put them in other vehicles. We may look at income tax laws for real estate. If you have real estate that is income earning, rental properties, might not want to put those in a trust. It may not be wise to do that. Why? The highest income tax bracket is that of estates and trusts. So if you have a probate estate or you have a trust and you have income that is being earned within that trust, that income has to be reported. That is the highest income tax bracket, right? There are other types of taxes. And so it may not make sense all of the time to put some assets in a trust because the way it performs. And so there's strategy. And so, I gave you a overarching, this is what these things are, this is what they mean. But true estate planning is really about strategizing to utilize these tools for the benefit of reaching the goals that you're trying to reach. And so when we talk about the high net worth, typically those goals are wealth preservation, tax avoidance, which is not illegal. Tax evasion is illegal. Minimizing your taxes, tax avoidance, not illegal. And trust can be used to do some of those things. But when I look at my client population, the high net, the regular middle class person, they're not as concerned about taxes because it may not apply to them. Some of the same tax rules may not apply to them. However, the strategy of estate planning is still necessary, and that is what you can't get from LegalZoom. That is what you can't get without a clear consultation of to understand your financial assets and the goals that you desire to reach and your family plan. You can't really get strategy to understand how you can utilize these tools. I don't know if you cook. I'm not a great cook. I'm not going to act like I'm Martha Stewart out here. But when you cook and you're preparing meat and you're preparing food, I watch my stepmother, my mother, these cooks, I watch these women, and they are meticulous about the type of tools that they use to prepare their meals, the seasonings that go with what. If they're using a meat grinder or a meat tenderizer versus a fork. And if my husband cooks and he's like, don't use a fork, you need to use a spatula, like really meticulous. I use that example because these things that we're talking about, wills, trusts, power of attorney, advanced medical directives, these are all tools that we'll pull out our toolbox to meticulously use to strategize and meet the goals that we agree is best for you and your family. And so I get annoyed with people who are like, well, I can go in LegalZoom and now the chat GPT, stop, just cut it out. Just stop it. Yes, you can go to these things, and yes, you can print off a document with your name on it and execute it and sign it. But are you fully aware that that document that you have read through and signed contains the information necessary for that tool to serve as the thing needed to accomplish the goal that you wish to accomplish? You have no idea because you don't even know what you're doing. And that's the realest I can put it. Does everyone need to go to an attorney? No, because we all have different levels and different things. But to the extent that you begin to, here's what I find. I find that most middle class people don't understand the value of the thing, don't understand the value of their possessions, and they wait too late to plan because they don't think that they have enough to plan. And if I can get in on a ground floor with information and serve as a trusted advisor as you grow, that is optimal. But the thing that breaks my heart, because again, I tell you, I plan from my common referral is for my clients to get a financial advisor. That is my comment. Before we even get into the strategy of estate planning, I'm like, you need to get a financial advisor. We need to get this under control today because you don't understand what you're doing to yourself, right? And so once we get some things under control, I can then strategize, and I help them bring other professionals in, and I am brokenhearted when I see individuals who are near retirement and they're getting older. And so now, and I use quotes, and I'm gonna tell you why. They're getting older and they say, well, now's the time for me to get the will and do the estate plan. And I say to them, thank you for working so hard. And what you're transferring to the next generation is wonderful. But my heart is broken because had you come 10 years earlier to me or anyone else, yes, I've been doing this work for 14 years. Had you come 10 years earlier to me or anyone else, we probably could have doubled what you've been transferring. But you didn't think that at that time, for whatever reason, there wasn't earlier planning. There wasn't a consultation. There wasn't something made in a way of retirement or long-term care. So now I'm at the juncture where I have to say, this is great. You work real hard. But because you didn't plan properly in these two areas, what you think is passing to Timmy isn't passing to Timmy. And the devastation that sets in it's heartbreaking for me. And so that's what I want to say. I want everyone to, the time is now. There's no time like the present. Even if you're late, today is not tomorrow. And the more time that you waste in not planning, is time that is lost. And the thing that we cannot get back, you can earn more money. You can get more money. I have watched money come into my husband and I, money comes in and money goes out. We've seen it. We haven't, we don't, I'm from the South Bronx. I'm talking about stuff that I've never learned. I learned this all from books and education. Okay. This is not passed down to me from my family. I don't come from wealth. I don't come from money. Okay. I actually come from a family of hustlers. So I don't come from this. And so me and my husband were fortunate enough at a young age to get people that we trusted, and we followed them blindly. And we were able to say, oh, snap, we bought a house young, but look, this actually works. This is actually a wealth tool. And so once you get bit like that by investment, you invest in, so we're good on retirement. We're good on real estate. We have diverse things. We were able to start young because we followed blindly. And if you don't have that education young, or you don't have those trusted relationships young, you have to just start where you are. And that's what I want. It's never too late. Start where you are. It's a meme that I just posted on social media by Dave Ramsey, that was like, if I save $25 a week or $100 a month for the last 10 years, I would be, my net worth would be X millions of dollars. And it's this fundamental idea that investment happens over time. And a lot of us in this microwave social media, world, we think that we can get rich overnight. We trying to be ball players and musicians. No, you have to invest over time. That's what the real estate game is about. That's what the stock market game is about. That's what everything that. So when you look at that life insurance, you get in early, you get in young, you get in early, you pay low, and you can get out high. You get good cash value. That's what the investment world is about. And so that's what I wanted to do. That's why I'm here.
Gotcha. So, in what you just discussed, did we already basically answer the question of who should be a trustee?
Hmm.
I believe you
Hmm.
did, right?
Hmm.
Also, you answered,
Well, let me
does,
clarify. Let me clarify. Don't just name anyone as a trustee. I have on my website, sherryfleming.com, on the bottom, it's a resources tab. I wrote what's called a difficult discussion guide. And this was developed just over conversations that I had with my family members. So they should know how to manage money. They should know how to make responsible decisions. They should know how to be unafraid to ask questions if they don't know the answer. They should have decent credit. There are some things that should be involved if you're going to name an individual. If you don't know an individual with a financial astuteness, and not just financial, but there are rules to serving as trustee. Like, you got to make sure the beneficiaries get notice of certain transactions. There's a legal responsibility to being a fiduciary. And so you got to make sure that the person that you name is up for this job. Because here's the thing, they can be like, no. They can say, no, I don't want to do it. And then at that point, what are you going to do? You can also name an institution as a trustee. And that comes with a whole boatload of strings and rules attached that I don't even want to go down that rabbit hole. But that is a possibility.
gotcha. So the next question I think you might have answered as well is, does a living trust avoid estate and probate taxes? You
Okay, so
spoke a little on it.
let's talk about this. Most of us, we not paying estate tax. And so here's why. At least federal estate tax. So, but it can be a concern for some of us. So there are two tax systems. Everybody know when they pay taxes, you're paying two tax systems. You're paying your state tax, and then you're paying your federal tax, right? Estate tax is the tax that the tax that is levied on the total gross value of your estate when assets are being transferred from your estate to beneficiaries, right? And so the gross value of your estate is anything that it is within your ownership, your incident of ownership, anything that you had ownership or control of. So life insurance, you may name your child as a beneficiary, but if you were the owner of the policy at the time of death, the value of that policy is considered a part of your estate for estate tax purposes, right? And I don't want to, this can get really complicated, so I don't want to go too much down a rabbit hole in it, but that's the gist of it. Anything that you own, the gross value of your estate at the time of death could be subject to estate tax. Now, there are exemption limits, meaning that the gross value of your estate has to be over this amount of money for estate tax to apply. In the state of Maryland, that amount is $5 million for a single person. And if you're married, that amount is $10 million for a married couple, meaning the gross estate has to be over $5 or $10 million in order for estate tax to apply. Most of us don't fall in that category. A lot of us can, depending on the real estate, depending on the life insurance policy, depending on the IRA, the retirement accounts. So some of us can be very close to that. Federal limits, most of my clients never even touch it. Every year, the limit is changed. So Maryland has been flat 5 million for years. Federal, the limit changes and grows with the rate of inflation, right? So I think for 2023, if I'm not mistaken, I lose track of this number because I'm like, it's insane at this point. So for 2023, I think the number is 12.7. So it was either 12.7 for 2023 or for 2022. $12.7 million for an individual, meaning that your estate for an individual has to be over that amount in order for federal estate tax to apply. That number is doubled if you are a married couple. It doesn't matter who, usually in a married couple, there is one person who is a high earner. And this is typical and kind of old. We're at a place where we have a lot of dual incomes, but still that number is double for a married couple. So it doesn't matter who makes what. If you're married, your total gross assets for the both of you have to be over 12.7 times 2, right? When you do the math, I'm not going to do it, right? I use calculators. Most of my clients don't have estate tax issues, federal or state. A lot of my clients are bumping up again, can get to the place where we're like, okay, if you live long enough, depending on your age and depending on the rate of the growth of your assets, you could possibly go over this. So we need to plan around that. A lot though, we're not planning around those things. The thing to be mindful of, 2026, there is a sunset provision on the law that allows for the increased federal limit. So it is possible without government intervention that the federal limit drops down to 5 million. Again, not covering most of us, depending on the value, depending on the value of the property we own, the value of the life insurance. This is why you need to tally up what you have. You need to know the value of what you own. You need to know, because depending on what jurisdiction you live in, you can live in certain parts of Maryland, own a property and have a good life insurance policy, and you're there. So it's very easy to get there living in Maryland. It's very easy to get there living in, the New England area. If you're lower and you're in the South, and again, these states have different rules, but property values are different there. The real estate is different. You can get a big house for, not as much money. So you have to know the rules of where you are. So the point is, in theory, estate tax exists. For many of us, we don't really have to concern ourselves with estate tax issues. The large majority of my clients don't have estate tax concerns. So this whole idea is, I need to get a trust to avoid taxes. They don't apply to you, no way. They don't apply to you. Estate tax don't apply to you. What does the tax you have to be wary about is income tax, because income tax applies to everyone. Income tax applies to individual businesses, estates, and trusts. And so you need to be mindful of what those rates are. And the reality is income tax is lower for individuals and businesses than for trust and estates. So again, we need to look at the asset. What other taxes? Then Maryland, not all states have it, but Maryland has an inheritance tax, which means that there's a 10% tax, 10% of the value of the asset being transferred. It's a tax that's levied when transferring the asset. That tax is levied on the recipient of the property, but your estate can elect to pay that tax for the recipient in order for it to be a true gift. And so that is something, and it doesn't matter what it is. It doesn't matter if it's $100 in cash. there is an inheritance tax. Here's some exemptions. It doesn't apply to lineal descendants. So if I'm receiving from a parent, grandparent, or someone in my lineage, the inheritance tax doesn't apply. If I'm giving to someone in my lineage, child, adopted child, inheritance tax does apply. Spouse of a child, inheritance tax doesn't apply. Where does it apply? Stepchildren, inheritance tax applies. Nieces and nephews, inheritance tax applies. Friends, inheritance tax applies, which means that we can't just be giving stuff willy-nilly to all kind of people thinking that we out here trying to bless folk, right? We need to be strategic in how we give these things.
Wow, 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 wow. And so, so there's some of what you discussed as well. Did it also cover benefits of living trusts?
Mm-hmm,
Kind of went through
mm-hmm.
some benefits, right? Okay.
So
Uh,
benefits would be, we talked about, avoiding creditors, um, avoiding probate, even though that is kind of tongue in cheek because it really depends on the jurisdiction you're in the states and trust rules of that jurisdiction. Because you don't always completely avoid probate because we already talked about there being items that you can't retitle, right? You don't have evidence of title, right? And so, you have privacy with a trust. So all of those things are benefits of having a trust. But avoiding taxes, you may avoid one type of tax, but you might have to pay another. We talked about the income tax. You may avoid one type of tax, but you might have to pay another. A lot of people say probate fees, administrative costs, which is typically estimated to be about 3% of a state. Like you want to have a trust because you want to avoid administrative costs, completely forgetting that there's administrative costs to actually having a trust. There's a cost to it. So you're swapping out one administrative cost for the other. At least in the state of Maryland, the recent changes in the law to make probate a little easier, the fees for administering an estate isn't as high as they used to be. Is it the best? Is it perfect? No, but it's not high as they used to be. And I can only speak for Maryland.
Gotcha. And so one of the other questions was the drawbacks of the living trust. That you spoke to some of that, right?
Yeah, yeah. The drawbacks is, is it for you? Is it for you? So when I talk to my clients and we talk about revocable trust and I begin to speak about, administration and, when you want to make changes to certain things and, different requirements, I say creating a trust, like I mentioned, having to get an EIN number, a tax ID number for a trust. Creating a trust is not the same, but similar to creating a business. There are certain formalities that have to be in place in order to maintain that business, for that business to be a legal entity, that have to have proper standing. And so the same is true for, I don't know if you heard that ringing. Did you hear that? I'm sorry, that was my daughter calling. The same is true for a trust, that there has to be certain things in place. And so the drawbacks may not be drawbacks for some people, but we hear the song and we know the saying, more money, more problems. It's the devil that you don't know. So it's not
Right.
that it's a drawback or it's a negative thing. It's something that you didn't anticipate, or you may not know. Some people may completely be fine with it, but when, depending on my clients, and I explain to them what they would have to do, they're like, yeah, no, I don't want to do that. I don't think I want to. I feel like being that, So it depends.
Yep.
Again, it depends on the individual and what they want to do.
Gotcha. So I think we took up more time than we wanted to with you. Are you okay with 4 more questions?
No, I'm fine. We had a little technical difficulty at the
Oh,
beginning. I'm on a
oh,
roll now. We can keep going.
okay. Okay. So I just don't want to take up your time. You got your daughter
No,
calling you and stuff. Huh?
you're,
Uh,
yeah, no, she's fine.
oh, okay. So will a power attorney be needed with the living trust?
Let's kind of go back to basics. So we talked so far. We haven't talked about a will. We talked about a trust. A trust is, and let me be very clear. You can see from this conversation, the trust conversation is a whole entire thing, right? When I typically give estate planning presentations, I don't even include trust conversation because I need to get a feel from the audience as to what they're ready and prepared to really hear, because it can be a lot of information. So when I typically do these presentations, I typically start very fundamentally and talk about the preparation for disability and death. And so a power of attorney and advanced medical directives, they are tools, again, tools, just like you have kitchen utensils, tools that are used in case of incapacity or in case of disability. When you pass away, they're no longer needed. And then you have your last will and testament that kicks into place. And if we're talking about, trust, we talk about having a revocable trust that would maybe go into irrevocable status at the time of your transition, right? And so when we're talking about a power of attorney for estate planning purposes, we're talking about a durable power of attorney. A power of attorney isn't a unique estate planning tool. A power of attorney could be used for anything, right? So I have family in Florida. I have staff in Florida because my firm is mostly remote. Even before COVID, I was modern before it was a thing, and so I thought about buying a property in Florida or establishing a practice in Florida, which I changed my mind about that altogether. But in thinking about that, one of the tools that I would use is the power of attorney. I would give it to my sister-in-law. I feel completely confident in her, giving her a limited power of attorney for the purpose of purchasing real estate. She can go pick it out, FaceTime me, show me some things, send me some pictures, and sign all the documents for me, and let's get it going. A power of attorney can be used for that purpose. When we're talking about using it as an estate planning tool, we're talking about a durable power of attorney, which is you giving authorization for someone else to act on your behalf, particularly if you ever get to a place where you are incapacitated and you are unable to make decisions for yourself. That's when it becomes an estate planning tool. Okay, so you have someone who is able to move your money and move your property for your benefit, not for their benefit. Like a trustee, they are fiduciary. So they're moving money for your benefit when you're in a position when you can't do it yourself. So a power of attorney, a durable power of attorney it is probably one of the most critical. I honestly, and this is my opinion personally, for what I see in my family, not necessarily my client, all my clients is different, but for my life, a power of attorney and advanced medical directive are more important to me than a will or a trust. And that's because of my situation. Most of my assets are jointly titled with my husband. If I drop off the face of the earth today, he got money. He's in control of it all.
Gotcha.
It becomes really a critical planning tool if both of us were to drop off the face of the earth and we got to put somebody in charge for the kids, right? That's really where our planning really is. That's the centerpiece. But if something only happened to one of us financially, we're going to be good. And that's only because we have all of our assets jointly titled. We got married. I was 2. Okay, so we got married before we started our career. So everything we have together. That's not everyone's situation, and I understand that. But so for me personally, and this is why your planning has to be critical to your situation. For me personally, yes, we're going to have a will, trust, all of that great stuff, right, for our children. But for my everyday, I absolutely need to have a power of attorney. I actually have multiple. Why do I have multiple? Because my husband has access to our finances. So he doesn't need power of attorney from me for our bank accounts. He needs power of attorney to get access to my retirement account, because again, that's solely, I'm not dead. I'm incapacitated. Okay. So he needs access for my retirement account because I am the only owner. Okay. He needs access to, I have multiple retirement accounts. So yes, he needs a power of attorney, but more important for me as an entrepreneur, I need someone to have power of attorney over certain things in relation to my business. I have unique circumstance with my law practice. So for you as a realtor, you know, with your business, everybody can't do your job. At least with Maryland realtors, the law does allow family members to step in the event of incapacity or death to run your real estate practice, right? But not for a lawyer. I can't have a family member. You're not licensed, you're not barred. So
Right.
I need to have another attorney I'm a solo practitioner. I'm not with a firm. So it's critical for my practice that I have another attorney identified, giving them power of attorney to run my business, at least the financial aspect, and give notice to my clients of what's going on, because that's the duty that I owe to my clients as their attorney. Utterly critical to my practice. Advanced medical directive, critical for me because I have walked with my mother having breast cancer. I have gone through her going through chemo and radiation. I've seen the importance of the necessity of being comfortable and living well while ill. I have cared for my father-in-law while he was on hospice care for 6 months. I've seen the decline in health and how important it can be for someone to know that you want the window open for fresh air. If I am in a position where I can't tell you what I want, it becomes critical for me now in an advanced medical directive to tell you what quality of life is for me. So my advanced medical directive is off the hook. It's clear. Y'all better comb my hair. Y'all better make sure my eyebrows are done. I want my nails painted. They need to be done. Whatever the doctor will allow as far as my nails, do it. I've been getting my nails done since I was 14 years old. It's the reason why I got my first job. It's part of the quality of life that I like for me. And now I want to go out like Coretta. Coretta had her nails. She was on her deathbed. Somebody was painting her nails red because that's the color she liked. That's what I want. I want urban jazz playing. I want the music. I want vanilla scented candles. That's what I have now. And so those quality of life things that we never really think about when it comes to estate planning, those are things that matter more to me than the money. And no, that's the area that people never think about. So when you come to me and we begin this process, that's where we start. We start
I
there.
never even heard this discussed. This is real good.
Hmm.
This is real good, real good. What's the difference between living trust and a will?
Well, a living trust, we already covered that. A will, that's the one item that we haven't covered. It's your last will and testament. It's your direction for what you want to happen to your possessions when you die. Again, we talked about a testamentary trust. So a testamentary trust is a will that says, I want you to create a trust. Or you can have a will that disperses property outright to people. Even if you don't have anything. So let's say you wrote your will when you had stuff and somehow you went bankrupt, you lost all your money, whatever. You don't have any possessions, right? If you have a will, at least the state of Maryland still requires that will to be probated, meaning you have to go to the court, tell the court, hey, this person died, they had a will, they don't have any assets. That's called a probate of no estate. Okay. And it's for you to just say this person lived, existed, and this person had a will, right? So that's why I say when people say, oh, I want to avoid probate, I go, well, even if you have a will, if you don't have a will and you don't have any assets, then it's like you weren't here. But if you have a will and you don't have any assets, there is still a legal duty for your personal representative, also known as your executor. There's a legal obligation for them to make your will public. Okay. So your last will and testament gives direction to the world as to how you want your assets transferred, right? That's one part of it. Another part of it is that you appoint guardians for your children. A critical part of the will is that you waive bond. So we talked about probate administrative costs, but we didn't talk about bond. Bond is a surety, basically an insurance policy that the person acting as personal representative or executive for your estate, they have to have that by law in order to act in this financial fiduciary capacity for your estate. And so in order to get bond, you have to have a credit check. there are many Americans who can't, there's many Americans who cannot pass a credit worthiness exam to get bond. So one thing that your will does and can do is that it can waive the bond requirement. And you are essentially testifying in your will that the person that you're designated is so trustworthy that you believe they can administer your estate without this requirement of bond. And I think that that is, so when people say, I don't need a will, and they actually own stuff, that waiving of bond is one of the most critical things that you can have in your will that you don't even know it's important. You don't even know the legal ramifications of what it is to waive bond. And so I think that is probably one of the most, between guardianship of minor children and waiving of bond, I think those are the most critical provisions in a will that people don't consider. What you can also do is reimburse for funeral expenses, because a lot of people go, oh, y'all can pay for my funeral houseway. What money did you leave aside? Did you prepay for your funeral and burial? Do your cremation? Did you prepay? If you didn't prepay for it, how is this getting paid for? Are you trusting that your sons, daughters, auntie, uncles, are you trusting that they're going to come together and pay for your funeral expenses? Do you know they're going to do it? Did you have a insurance policy that you took out to get this paid for? And who did you name as the beneficiary? And are you sure they're going to use that money for this? Because they don't have a legal obligation to pay for your funeral with this insurance money. So how are you going to be buried and or cremated? Or cremated, if that is something that you desire to do. So what the will does is allow for whomever is paying for the funeral expenses to be reimbursed. Because the reality is, once you die, if the asset is solely titled to you, your bank, once that funeral home pulls that death certificate, everything solely titled to you is on lockdown. There is no money shifting. There is no money moving. You better have $10,000 under a mattress. Otherwise, how are you paying for yourself to get back? Like, how are you paying for this? So that's another practical concern that I bring up for a lot of my clients, that they're like, I don't know, I don't know. A lot of my clients will say, well, I'm paying for insurance, and they have 15 beneficiaries listed on the insurance policy. Well, the only way that's going to be used to bury you is if all 15 of these people get together and agree to sign this policy over to the funeral home. That ain't happening. That's not happening. So how are you going to be buried? Who is going to be burdened with this task? And I use the term burden because that is what it is. I work with families all of the time, and I need to be crystal clear that burying someone and giving them their last rites is a weighty responsibility, that you will know the test of someone's love for you when they do that, and you won't even be here to see it or receive it. And so I say that estate plan. So when you ask me, back to your original question, what is estate planning? Estate planning is your final act of love. It is planning, creating provision for those whom you love and those you are leaving behind, to make their grief and their transition to life without you easier. That's what estate planning is. And if we think about it that way, we get out of, I don't have enough money. We get out of, I don't need a will. We get out of all of that. It is your final act of love. I think my light just cut off. Let me see.
Light went off.
Did it? It did. I don't know what happened. Oh, I'm dark now.
Well, we're going to get you off in a few seconds. So real quick. So in other words, to sum it up, you need a living trust
And
and you need a
I'm
will.
still here. I'm just working on
We
this
got you.
light.
No problem.
Yeah, to sum it up, you definitely need a will. You definitely need a power of attorney. Do you need a living trust? That will depend
Gotcha.
on what it is that you have and how you want to transfer it. I think we're having a power issue, actually. And I don't know how that exists. I think it's on one side of the room here. Oh, this is crazy. Well, it's what, yeah, I just noticed. I'm like, I think we're having a power issue because my computer's not charging anymore, but it's fully charged. So I'm here. So let me take this blur off so you can actually see me.
So, the last thing, and the lights went out just in time because we're almost finished. The last thing, who do we need to come to create a living trust? And I want to think it's you.
If you're in Maryland, definitely come to me. I'm gonna take all of the clients here in Maryland. So this is weird. I'm wondering if this is the sunlight. Yep. I'm trying to figure out why it's not more light, but that's actually what happened here. I think our power just went out for a second. So if you're in Maryland, you can come to me, sherryfleming.com. If you just want to join our Legacy Matters Money and Memories.com. If it depends on what, honestly, if you work with a financial advisor, you have a good relationship of trust with, a financial advisor, start with them. They know you well. They may have some referrals for you as far as attorneys are concerned. But I'm not going to ever say, no, don't come to me. But so, yeah, if you're in the state of Maryland, come to me. If you're not in the state of Maryland, you can contact your local estate planning council. Like I am a part of the Baltimore Estate Planning Council, because that's the region in which I practice. But you can look up, any estate planning council and maybe find someone. Usually when they participate in this professional network, they're in the industry for real. They're not a criminal attorney who drafts a will every now and again, right? But they're in the world of estate planning for real, which it's an industry. So I do know a lot of attorneys that go, oh, well, I could draft a quick will for you here and there. And I'm like, don't do people a disservice. Don't do that. Have them go to someone who does this day in and day out. You see that little AEP with that registered trademark. That means either I'm an accredited estate planner, and it's really for a designation to say that I work in a collaborative fashion with other professionals, CPAs, financial advisors, trust advisors, philanthropic officers. I work with a cohort of people to accomplish goals for my clients. You can have an AEP and not be an attorney. So you can be a financial advisor and have this designation. It's just a designation to indicate that we really know what we're doing. And so you can look up the National Council of, National Associations of Estate Planners and Councils. So these are, professional associations that you can look up. If you are looking for an estate planner of color, and the reason why I say that is because it is very important when estate planning that you receive culturally competent advice. And I actually went to a conference yesterday with my fellow colleagues. I'm the only brown person in the room, and I had to explain what this is. And it's really having a historical understanding of a culture of a people and how they engage planning and the questions you don't even know to ask. Many professionals don't even know that there are specific questions that should be asked, which are legitimate. I think, did it cut? Oh, it did cut off? Okay, thank you. There are, someone else saw my struggle. There are many professionals who don't know to ask certain questions because they don't, you can't assume culture. I have represented a lot of individuals of varying religious backgrounds, which for the sake of being a curious representative, that I know more than I ever knew about planning for them. I wouldn't have known without asking certain questions. So you want to definitely make sure that you have culturally competent representation. So with that said, there is the Alliance of Black Estate Planning Professionals, which includes a whole cadre of brown folk in different areas, the Black estate planners, Black accountants, Black CPAs, Black philanthropic officers, Black elder law attorneys, because there is some cultural differences that we need to be unafraid to articulate as such. It's not a good or a bad thing. It's just different. It's just different. And I can tell you by being in its professional associations that it's real. And we don't get the same treatment, not because of just overt discrimination. When you're not of a part of a culture, you simply don't understand it. And that's just what it is.
Wow. Well, a wealth of knowledge you really are. Thank you so much for taking the time to spend with us. And we ran this thing way over so that we can
I
hear all.
know, I'm sorry.
No, no, no. That's good content. That's what people come out for, is that to hear the information. And one of the reasons why I reached out to you and I wanted to get you on is just for this, because exactly like where you are, I am as well. I want to get as much information out there, especially on the things that I know that a lot of us don't have a clue about. And
Mhm.
I really, really, really appreciate you for taking the time through the technical difficulties and everything to share this wealth of knowledge with us. And I hope we can have you back and we can talk about some of those other pillars of the estate planning at some
I'm
point.
always here. I'm always here and up for conversation. And I promise you the lights won't go out.
Hey, well, I can't promise you it won't go live right away because I'm going to do too many promises. Hey, but sir, it's been a pleasure to have you on and have the folks get to hear the wealth of knowledge that you have. And I thank you again for coming out. And I look forward to building a business relationship with you. And we'll see how we can help some folks in the future. Thank you again.
Absolutely.
And it's another Hump Day Real Estate with Ken Bell, and we're signing off. Thanks again, Sherry. I'll talk to you soon.
Have a good day.
Have a good one.